So, good morning, good afternoon, good evening. We're now recording live from CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, our demand for a Women's Bill of Rights to ensure that women all over the United Kingdom have women's rights as human rights and human rights as women's rights. So I'd like to introduce all of us. We are here this evening, this morning, and this afternoon with a panel of 5 wonderful contributors. I've got a bit of annoyance in the background, sorry. We have with us Nazir Afzal, who is former Chief Crown Prosecutor, Dr. Sarah Sargent, Reader in Law at the University of Buckingham, Debbie Allen, political activist in the Black Lives Matter movement, Moira Rayner, barrister and former Equal Opportunity Commissioner, Helen Flynn, Head of Policy and Research and Campaigns with Just Fair. And I'm Dr. Jocelyn Scott, and I have been the president of the CEDAW People's Tribunal, which is putting forward the proposition that we must have a Women's Bill of Rights that incorporates CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, into domestic law as a Women's Bill of Rights. I'd like to now hand over to Nazir Afzal, OBE, who was Chief Crown Prosecutor for North West England and formerly Director in London. Most recently, he was Chief Executive of the country's Police and Crime Commissioners. During a 24-year career, he has prosecuted the most high-profile cases in the country and advised on many others and led nationally on several legal topics, including violence against women and girls, child sexual abuse, and honour, or we might say dishonour-based violence. He had responsibility for more than 100,000 prosecutions each year. His prosecutions of the so-called Rockdale grooming gang and hundreds of others were groundbreaking and drove the work that has changed the landscape in the area of child protection. He is chair of Hopwood Hall, sits on the Independent Press Standards Organisation, is national advisor on gender-based violence to the Welsh Government, independent member of Oxfam's Safeguarding and Ethics Committee, and trustee of the Association of Safeguarding Partners. His memoirs, The Prosecutors, were published in the year 2020. In 2021, he was pro bono legal advisor to the CEDAW People's Tribunal. And so I now, with pleasure, hand over to Nazir Afzal. Nazir.
Thank you very much indeed, Jocelyn. I apologise for the length of that biography. It's not my fault, but that's just the nature of these things. I feel very privileged and honoured to be in such a phenomenal company, in such esteemed company, and even more honoured to be the only male on this panel, because as we'll discuss, the issues that we need to address involve men changing their behaviours. As you will imagine, being a prosecutor and having spent my career in justice, the lens through which I see this is the lens of violence against women, domestic abuse and sexual violence. And I think we're at a tipping point, one that, in all my years I've never really felt that we had got there, we are now having a conversation about the things that we need to have a conversation about. For too long, the issues have been seen as an issue of women's safety. We talk about women must do this and women should do that. Well, in actual fact, it has always been an issue of male violence. And it's about what men should do differently rather than what women have to do differently. And the government are at fault here. The government's immediate response to terrible murders or femicide tends to be more street lighting. We'll put £100 million more into safety, give you alarms, all of which miss the point. That women wouldn't have to have alarms. Women wouldn't need to know how well lit the places are if men were able to control themselves. And I've prosecuted more than 100 femicides, more than several thousand rapes and sexual offences. And I can assure you that not one of those sexual offences was about sex. They were all about power and control. They were all about men exerting their power and control. So why is this important? Why do we need CEDAW to be incorporated into our law? Because I think that is the only way that the state and all of the institutions of the state will begin to understand what their responsibilities are. That will also address the issue about why men need to change, because men will need to change because women will have rights. Every time I have a conversation with government ministers about this subject, they always talk about the Equality Act 2010 and say, well, you know, we don't want a hierarchy of rights. And my response to that, well, you know, women are the majority in this country. And therefore, by default, there ought to be a hierarchy of rights that puts women's rights at the top of that. And we spend far too much time on criminal justice responses, or the lack of a criminal justice response, and very little on what we can do to prevent harm from happening in the first place. And that's why I think the work that we're now doing, particularly in Wales, where I'm advising, is around the public health approach. Because we know that violence against women is the largest risk to health than blood pressure, than obesity, than pretty much anything that you can think of. It also has absolutely mind-blowing economic costs. If you don't want to think about the moral dimension, think about the economic cost. The Home Office say that the cost of domestic abuse to UK GDP is, wait for it, £66 billion a year. That's double the education budget, double the defence budget, and that's not just justice costs a small part of that. It's loss of taxation, it's loss of all the welfare provisions, the impact on children, the impact on families, the impact on communities. So there is a business case to tackle this. There is a moral case. There now needs to be a legal case. And that's by giving women rights in order for them to be exercised them and for people to be held accountable when they fail to do so. Now, the government always talk the talk. They talk about royal commissions. They talk about task forces. They talk about programs that they will develop. But the reality is that they're still tinkering around the edges until such time as they are forced to do so by a Bill of Rights for women. And, you know, why do we focus on the end game? Which is, you know, every time I dealt with a prosecution, I always saw it as a failure because somebody had been harmed to get to me, I mean, invariably a woman. You know, 2 women every week in this country, in the United Kingdom, are killed by their partners or ex-partners. 10 women kill themselves every week because of domestic abuse. 1 in 4 women will be subjected to domestic abuse at some time in their life. 1 in 5 will be sexually assaulted. 97% of women told a government-wide survey earlier this year that they have suffered sexual harassment. That is the pandemic that will outlive this pandemic. And that's why it requires the same level of response, or to be frank, a better response than the way our government has dealt with the pandemic. And that's relentlessness. And that's about ensuring that rights are upheld and women are given the rights that they can uphold. It's about men being held to account when they breach them. It's about men understanding what their responsibilities are in society rather than putting all of the burden on the women that exist in our society. We need to address inequality. We need to address misogyny. We need to address the root causes of harm in society, not just through an early intervention and de-escalation and criminal justice responses, but actually addressing what causes it. And you know, misogyny if you're a person of Abrahamic faith, misogyny started in the Garden of Eden. It's the oldest bigotry, and one that will continue unless we address it in the way that a Bill of Rights will enable it to be addressed. And we can't simply say safer streets, better policing. The reality is the stories that you keep hearing from victims and potential victims will continue to grow. And we've had, as I said, right at the outset, I think we've reached a tipping point. The murder of Sarah Everard by a serving police officer, I think, sent out a stark message as to who you can trust. Everyone's Invited was a website that asked women to submit tens of thousands of stories of sexual harassment and sexual abuse. And, we know what's happening. We know what is going to continue happening if we don't address it in a different way. And that's why a Bill of Rights is the key to that. And CEDAW, it's been in position for 4 decades now. And you would think that would have made a significant change. And we always find government finding excuses which tend to revolve around money and tend to revolve around cost and the lack of resources. But if there was a Bill of Rights, they would then be required to find the resources. And of course, as I said a moment ago, the cost of not doing so means that the resources will continue to be wasted. So we've got to put in place something that changes the discourse and changes the narrative. And that's why I support a Bill of Rights. That's why I support the incorporation of CEDAW into British law. And that's why I will work tirelessly, if I can, and relentlessly, to ensure that our ministers, our government, and our governments bring this into being. Thank you.
Thank you so much, Nazir Afzal. That's very much appreciated. And now I'll hand over to Dr. Sarah Sargent, and we'll come back at the end for questions, discussion, and cross debate between our panelists and questions from others from the outside. Dr. Sarah Sargent is a reader in law at the University of Buckingham. Her research and teaching interests include international human rights. Prior to taking up work in academia, she was a practicing lawyer in the United States. Her licenses to practice are now inactive, but at that time she was working extensively on issues of family law, including issues of domestic abuse and children in the care system. Before arriving in the United Kingdom, she worked for several non-profit organisations, including work in the capacity of managing attorney and director of legal services. Her legal practice included extensive litigation experience and filing briefs of amicus curiae with the state appellate courts on children's rights issues. She is also one of the founders of the non-profit organisation Kansas Association of Counsel for Children, an affiliate of the national organisation, the National Association of Counsel for Children. She has served as a board member and past president of this organisation. Sarah Sargent also served as a member of the Kansas Judicial Council Juvenile Offender and Child in Need of Care Advisory Committee for 7 years. This group was responsible for a review and revision of state laws on juvenile offenders and children in care. Dr. Sargent has previously taught as an adjunct professor at Washburn University in the United States of America on children's law and comparative law method and theory. She also taught at De Montfort University. Her ongoing research interests include Indigenous rights in international law, transnational legal theory, and the intersection of Indigenous rights and children's rights in both international and domestic law. At the University of Buckingham, her teaching brief, in addition to international law and evidence, also includes medicine, law, and ethics, which of course raise questions about children's competency and health law and women's and children's rights. And I now hand over with pleasure to Dr. Sarah Sargent.
Thank you, Jocelyn. It's my absolute pleasure to be here this afternoon and also to be part of a panel of people bringing together views on this very important discussion. So I'm going to be talking from the perspective of violence against women, and not only domestic violence against women and girls, but domestic violence against women and girls with disabilities. And I'll be talking about why it's so important to have this Bill of Rights that's put into domestic law. And the first thing I would say about domestic violence is that it is often rendered invisible. And when domestic violence is invisible, although it is a recurrent and common problem, you cannot remedy what is not acknowledged and what is not seen. And so having a Bill of Rights that specifically addresses not only women's rights, but provides rights to protect and safeguard and prevent violence against women is a first important building block in addressing this. So in discussing violence against women, CEDAW itself began with no specific reference to domestic violence or abuse within the instrument itself, although this has later been addressed through a couple of general comments issued by the committee that oversees CEDAW, and I'll come back to those in a moment. Domestic violence and abuse is one of the most pervasive violations of the rights of women and girls, but the wall of silence around it makes it very difficult for it to be addressed. This wall of silence makes it hard for women and girls who experience this to speak about it. And when it's not spoken about, this wall of silence then becomes a shroud of shame, where survivors and victims feel stigmatized and shamed and do not speak up and do not get the help and safeguarding that they are entitled to. So including provisions that acknowledge the existence and occurrence specifically of domestic violence in a Bill of Rights is a critical step. It is the first step, but without it, it's difficult to confront domestic violence at a domestic level. And it can be the first building block to help build an effective and coherent legal framework for domestic violence. Back in 1992, a general comment that was issued from the committee that oversees CEDAW clarified that domestic violence is included in the definition of Article 1 as discrimination against women. This general recommendation was then updated in 2017 by General Recommendation 35. General Recommendation 35 says that prohibitions of violence against women and girls are now part of customary international law, such that this prohibition applies everywhere to all states. But this actually doesn't do anything in a practical way to assist women and girls, because this adds nothing to domestic frameworks and does nothing to aid women and girls in a way to effectively reach the assistance they may need legally, to provide access to rights and access to education about their rights. One of the things that struck me back when I was practicing law was that women and girls who were survivors and victims of domestic violence often were unaware that the things being done to them weren't okay. They had grown up in an environment or lived in an environment where the types of things they experienced were just seen as routine and normal. And it was often a revelation to them to find out that actually there were laws, both civil and criminal, against the things that were being done to them, and that there was help. And this is something that sticks with me and comes to me even now as I speak. It's very poignant, because all of the laws in the world are not going to help people if women and girls do not have access to education about rights and do not have a way to effectively access those rights. And I believe that this Bill of Rights for women is, again, a very important first step. Now, fortunately, General Recommendation 35 goes further than acknowledging a customary international law prohibition against violence against women and girls. It provides guidance to states on what must be done to address domestic violence in domestic arenas, and says that in many places, existing legislation is poorly implemented or is inadequate. And I would suggest that the domestic legislation in the United Kingdom certainly could benefit from the types of support we would see in a specific Bill of Rights. The general recommendation says that states are required to adopt legislation that prohibit all forms of gender-based violence. And this is something that the Bill of Rights would help promote. Now, I'd like to turn my attention to the issue of violence against women and girls with disability. And this was the focus of a July 2021 UN Human Rights Council panel discussion. And this discussion highlights, again, the problem with invisibility. This panel spoke about the lack of limited data and the problems to raising the visibility of the occurrence of violence against women against women and girls who have disabilities. And the panel report says, and I quote, speakers noted that despite the best efforts of countries, women and girls with disabilities continue to suffer disproportionately from violence and abuse, facing unique and pervasive barriers to the realization of their human rights. End of the quote. The legal framework that we have for victims and survivors of domestic violence is one that I find to be fractured, incoherent, and difficult to navigate. It has provisions for non-molestation orders, occupation orders, and other remedies, and now an offense of coercive and controlling behavior as a criminal offense, which begins in itself to recognize the nature of domestic violence. But this is a criminal offense, and there can be many reasons that women and girls who've been victims and survivors of domestic violence do not or cannot bring criminal action. And this framework does not do enough to deal with violence against women and girls with disabilities. A Bill of Rights can address this in a more coherent and effective framework, and also serve as an important vehicle for raising attention and awareness, and provide an effective legal framework. And I see that my time is up, so we'll leave my comments there.
Thank you, Dr. Sargent, and we'll come back to Dr. Sargent with questions in due course, that is at the conclusion of the speakers. I'd like now to introduce Debbie Allen. Debbie is BAME officer with Ealing North Constituency Labor Party. BAME is Black and Minority Ethnic. As a committed activist and organiser, she works to ensure that the voices of Black and minoritised women gain their right polity with election to local government, to parliament and to public office, and participating equally in employment in all trades and professions. She holds a regular monthly online discussions on topics of political and public importance so as to promote BAME issues within the broader society. One of her aims is to build a stronger band of mentors for and within the BAME community so that knowledge of the workings of society at all levels can be incorporated into the lives of those who attend the sessions, with a mentoring scheme providing added value to mentors as well as to mentees, in the recognition that everyone, whatever her or his station or status, background or foreground, has a contribution to make and a learning curve to negotiate. None of us has nothing to learn, just as none of us has nothing to teach, imparting our knowledge to others to promote understanding and affiliation. A public speaker, Debbie Allen has addressed the online series Brilliant and Bold. She's been a keynote speaker at a general committee meeting in Cambridge, is scheduled to speak at a Buckingham University Law Students Association function, and most recently has spoken out on issues relating to the objectification of women and women's bodies. At a younger age, through her naivety, she gained personal experience of beauty pageants and beauty pageanting. That experience brought the realization to her that no woman should have to use her body as a platform for any issue. Women, she says, should be heard and be invited to discussion panels based on their subject matter knowledge and passion to resolve societal issues. She promotes diversity training for all who enter elected office and believes that change will come about only when women of all backgrounds are recognised as equal, and that the equality of Black and minoritized women stands as a beacon to be striven for in order to create a better world for all. I hand over now to Debbie Allen. Debbie, if you can turn on your camera just for a short time, that would be lovely. Debbie's in a car and therefore in difficulties with transmission. Thank you, Debbie Allen.
Thank you so much, and what an awesome introduction. I was actually regretting continuing my continuing my further education when I am amongst doctors. So thank you so much for that, Jocelyn. Oh wow. Why do I support this bill? I have to support this bill because I have experienced domestic violence. I've lived in a woman's refuge, and I recently shared with Ealing North Women's Forum some of the experiences that I had in that women's refuge. When you talk about the unseen disability and unseen other effects, you're left with mental health issues, lack of self-confidence. And another major thing that I haven't really heard yet is the financial abuse, because sometimes when a relationship breaks up, the first thing that your partner does is hide the finances, and then you're scrambling around trying to live to a standard that you and your children, if there are children involved, were used to. So sometimes that means taking on another job. And I remember working 3 jobs, and of course that impacts on the children, because when you're blessed with children, a woman's role, I believe, we are nurturers, we are the carers, we're the first point of contact to these blessings, and we shouldn't be working 2 and 3 jobs. So men should be held accountable definitely for that, and it impacts on children and families. I think, latchkey children have to grow up before time. I'm here not only to give a perspective as a woman, but also as a Black woman. And if I could just ask you about the term BAME. If you do your own Google research, you'll see that a number of Black people and groups have refuted the BAME term, and some have embraced the AIM term, that's African, Asian, and minorities of a global, global impact. So what more can I say? We have to acknowledge domestic violence and all its strands, the seen and the unseen. We have to define it, and then we have to educate it. We need to see more men working in nurseries and in schools, and we need to see more women working in engineering and construction. And so with the sharing of these roles, I think that can be the only way that we understand each other. you know, our speaker before gave us the 66 billion that it costs to address all the harm that's done after it's impacted on society. So, you know, from a very young age, women and men, young boys, need to know about gaslighting, the effects of domestic violence, and we have to try and leave this planet that we live on in a better place for our children. I'm happy to take questions after, and I thank you so much for inviting me on this platform. As my role as co-convener for West London to Stand Up to Racism, I'd like us to acknowledge Martin Pitt, who recently passed away, and he was an advocate against any form of ism, and in fact, he was one of the organisers that organised a petition against violence against women, and they protested outside a train station in Ealing against Muslim women who had been attacked. So we just want to honour the men that do come up and stand up for the protection of women. Thank you so much.
Thank you so much, Debbie Allen, very much appreciated. And we will come back to you with questions after we've heard from Moira Rayner and from Helen Flynn. Thank you. I'd like now to go to Moira Rayner and introduce her. She's actually sitting in Melbourne, Australia, and it's now 12 midnight or thereabouts, 12:30 midnight. Moira Rayner was born in Aotearoa, New Zealand, and she's now based in Australia as a barrister and human rights advocate. In 1986, she was appointed a commissioner of the Law Reform Commission of Western Australia, a position she held until 1990, although in 1998, she was appointed to the commission once more, this time as chairperson. In 1990 also, she was appointed the third commissioner to the Equal Opportunity Commission by the Victorian government, that is the Equal Opportunity Commission of Victoria, which was originally established in 1977. In that role, she undertook many landmark cases as commissioner, and was responsible for monitoring the Equal Opportunity Act, the Racial Discrimination Act, that is a federal act, the Human Rights and Equal Opportunity Commission Act of 1986, another federal act, and the Commonwealth Legislated Sex Discrimination Act of 1984. In 1994, the Australian federal government appointed her to the Institute of Family Studies to undertake a special project to fight child abuse. In 1987, she completed a Churchill Fellowship on the rights of children in the legal system of the United Kingdom. And in the year 2000, Moira Rayner became the first director of the Office of Children's Rights Commissioner for the City of London in the United Kingdom. Moira Rayner used her time in her official positions and as an author and activist to address issues and support campaigns for the rights of women and children in society, the rights of children in the legal system, and she supported campaigns in all these regards and continues, of course, to do so. Many of her activities in these spheres have been innovative and thus publicly and politically controversial. As one might say, one never can make steps forward and take positive action, particularly for the rights of women and children, without being controversial. From 1990 until 1994, Moira Rayner held the office of the Victorian Commissioner for Equal Opportunity, and in 1994, there was a dispute with the Victorian government regarding Moira Rayner's strong stance against the closure of women's prisons in Victoria. And as a consequence of all this, the Kennett government in power at the time was not appreciative of Moira Rayner's efforts for women's rights and the rights of justice. Late in 1994, the Australian federal government appointed her, as I said, to the Institute of Family Studies. And we've had Moira Rayner working in London in the Children's Commission, as I said, due to her appointment in the year 2000. She is now back in Australia, and she will now come to us from Melbourne, Australia at midnight. Over to you, Moira Rayner. Moira, you're on mute.
It's a stupid mistake to make, and that's one I'm very proud to have made to show that I am but human. I am sitting on land which was never conceded to the settlers that arrived, the original settlers being convicts in Australia. It's now, as I said, 20-1 in East Melbourne, and I am on the land of the Wurundjeri people of the Kulin Nation, and I acknowledge that this was stolen from them, and I benefited from it as a late immigrant, a boat person from New Zealand. I would like to support this project very much because I am very well aware of the need for women and children and people of Indigenous and other minority cultures to have a stand at the decision-making tables when we are considering the way we are going to live now. In Australia at the moment, we have a large issue, which is more than a pandemic of a COVID-19 infection. It is a pandemic of violence against women, which has become infinitely worse under pandemic conditions and has become a very highly influential group of people who are deciding to take some action about it. Earlier in the pandemic era, in 2020 and the beginning of 2021, the issue of sexual violence against a person who worked in the Australian Federal Parliament became a highly important issue because the young woman, Brittany Higgins, who said that she had been subjected to violence, was actually working for a minister in the current government when she was raped in the minister's office. And when she complained about it, was told that her job was on the line if she continued to raise the issue. When she did raise the issue, it became a matter of deep shame that the Prime Minister was not prepared to in any way interfere with the complete lack of protection this young woman had. And it led to a massive movement of women approaching their own parliaments in each of the states and the federal government to say that the issue of violence against young women who should be protected from it was a matter which was deeply important. The Women's March was a remarkable experience and one in which I participated. Around about the same time when Brittany Higgins' appalling condition arose and the fact that the matter had never been investigated became scandalous, she was joined by the Australian of the Year, Grace Tame, pointing out that violence against young women, which she'd been subjected to as a student and a pupil in a school by a school teacher, was now completely undealt with and needed to be addressed in a significantly different way because of the complete impunity with which her attacker, who was jailed eventually for his offences, managed to participate in a notorious podcast in which he boasted about how lucky he was to have such a young sexual partner. We have in Australia a number of pieces of legislation which seek to address on a federal and on a state level issues about the lack of equity and the lack of gender equality, as well as many other issues. But the one that really strikes me very hardly is the fact that family violence against women and children and family lack of support in young children and families has become an extremely serious issue, particularly in Indigenous communities. There is an enormous disparity, about 8 times the number of serious offences of a violent nature against women in Indigenous communities. Australia, I might point out, was based on the lie that there are no such people who occupy the land that the people in the boats came to in the late 1780s, the terra nullius idea. And the resulting attack on the people in Indigenous communities was never truthfully told, and has only recently been the subject of public meetings and attempts to raise these issues in a state-by-state basis, the federal government refusing to do so. What is the worst aspect of it all is not just the violence that is being subjected to and being ignored by the leaders in this country, and is ignored as a matter of course in many other countries, is the fact that our federal government decided to, as it had always wished to do so, abolish the Family Court of Australia. The Family Court of Australia was set up in the 1970s and was intended to provide access as lay people to children, women and others on an equal basis with access to child care, a free mediation, the lack of necessity to pay for lawyers, and required fair distribution of family assets in the case of the breakdown of a marriage. There are equality legislations in each of the states and territories, but what has happened over the years is that the rights to access remedies of people who are underrepresented in the education and financial resources of the country has been gradually legalised, litigated, and become extraordinarily expensive and inaccessible to women, so that they cannot now readily either go to an equal opportunity commissioner or seek to apply their rights and get a remedy when they have been treated unfairly and discriminated against in the matter of their rights, particularly at work. May I just say, I'm currently acting for one of those women at the moment who's been working for 20 years in a state instrumentality and has been subjected to brutal sex discrimination through the whole of the period of her life, and has found that the only way in which she can protect her workers' rights is to approach a federal court and somehow find the money to pay for a law firm to ensure that she is not made redundant because she has objected to it. She's been victimised on a serious basis. This is a very serious issue in every area, which is why access to justice is tremendously important. The first thing that is required is that there is a clear statement of the right to equal rights by women, and especially Indigenous women and refugee women. And there is no longer, and there needs to be, proper access to courts, tribunals, and to the means of having your voice heard, simply because of the gradual elimination of the actual respect for women's rights. What are issues that may approach some, at least raising of those issues, are on a piecemeal basis, but they have some value. Some states in our country have decided to establish charters of human rights and responsibilities. Victoria is one of those. The state of Queensland is another. They do give women equal rights. They do not, however, provide an easy way to challenge discrimination in their daily lives, because one has to go to a law firm and seek to implement the obligation on agencies to make sure that they consider the rights of women in particular, but not only women, when they're making decisions which are likely to affect them. This lack of representation is an issue that I want to emphasise. If one has a charter of rights for women, if one implements the international conventions on which our countries take a stand by signing up to them, then there must be a means of ensuring that those rights are, if transgressed, protected. One other thing that particularly is happening in my own state in which I am actively involved is the establishment of a Commission for Gender Equality, in addition to the Commission for Equal Opportunity, in addition to the Federal Human Rights and Equal Opportunity Commission, now known as the Australian Human Rights Commission. And the Commission for Gender Equality is taking some action based on the Charter of Human Rights to ensure that all government-funded agencies have a gender equality action plan. We've only just started doing this, but it requires all of them to publicly audit their experiences and their workplace to ensure and be publicly accountable for workplace gender composition, the composition of their governing bodies, pay equity, achievements or non-achievements, the degree of sexual harassment, the ways in which they recruit and promote people, their provision of leave, especially flexible leave and parenting leave, gendered work segregation, and gendered promotion and representation in the important issues. I could go on forever, but I would simply like to say that without the rights to be treated with dignity and respect, and equally being capable of being raised, of being publicly accountable, and of having access to support to raise the wrongs that are so regularly done to women, there is no actual acknowledgement that women hold up half the sky when they are actually doing more than half the work and receiving less than anybody else for the efforts that they do for the productivity of the economy, which is no longer, we now know, the golden grail, the human, the grail for which we should achieve. So I will leave it at that, which is a bit of a mélange, and say that Australia is no shining knight, and the United Kingdom could give an enormous boost to the rights of women by adopting a CEDAW within its internationally accountable human rights legislation, but it must also address the ways in which those rights can be enforced in a public and accountable way. Thank you.
Thank you so much, Moira, for your contribution. Much appreciated, and questions will be coming shortly. But I'd like now to hand over to Helen Flynn. Helen Flynn is the Head of Policy, Research and Campaigns at Just Fair, an organisation which has had its head location at Doughty Chambers in London, whilst Helen Flynn is located in Northern Ireland, where, as we know, advances in women's rights can be problematic, and yet women speak out strongly and have ever been strong political activists. Just Fair brings social justice and human rights together, working to ensure that United Kingdom law, policy and practice complies with domestic and international human rights obligations. Helen holds a Master of Laws in Human Rights and Criminal Justice from Queen's University in Belfast, with over 10 years' experience researching and campaigning on behalf of non-government organisations, NGOs, community groups and grassroots organisations. Helen has been working consistently towards the better realisation of human rights. She has a particular interest in the domestic implementation of international human rights standards and has worked to find ways to better facilitate access to United Nations monitoring mechanisms for those engaged in grassroots human rights work, both in the United Kingdom and Latin America. Helen Flynn has long worked on the progression and implementation of these rights standards and has submitted to a number of United Nations human rights monitoring mechanisms over the years, including CEDAW, that is, the Convention on the Elimination of All Forms of Discrimination Against Women, as well as on the Convention on the Rights of the Child, the Convention on Economic, Social and Cultural Rights, and the UPR, that is the Universal Periodic Review. This is a process whereby the human rights records of all 193 United Nations member states are reviewed. Helen is a member of the Northern Ireland Women's Policy Group, where she has contributed to both the Feminist Recovery Plan and the updated Feminist Recovery Plan, as well as having hosted events focusing on CEDAW. So now I hand over to Helen Flynn. Helen.
Thank you so much for that wonderful introduction, and thank you also to everybody who's gone before me for those really illuminating contributions. I'm going to therefore take a slightly different tack. I'm going to talk firstly for a little bit about why CEDAW, the actual convention, is so special within international human rights law. And then I'm going to focus a little bit on why the domestic implementation of CEDAW is so important in the UK at this particular juncture in our constitutional timeline. Sorry, computer playing up. So firstly, one of the first things I want to highlight about CEDAW is that it deals not only with direct discrimination, but also with indirect discrimination. And that was groundbreaking at the time. Also, Article 4.1 allows for what they call temporary special measures to accelerate de facto equality. So that's about the government being able to bring in special measures, or sometimes that's called positive action, in order to level up equality between men and women. The treaty also covers not just intentional discrimination, but unintentional discrimination. And it's not just about the actions and omissions of individuals, but it's also the actions and omissions in law and also societal structures and institutions. So all of that is quite groundbreaking. But in addition, CEDAW breaks with the generational hierarchy of rights, where civil and political rights were deemed to take priority over other rights, such as social and economic rights. CEDAW sees these rights in a more holistic framework that reflects how people actually live their lives. And then what's really important for me, and has been raised already in this, in how it deals with domestic violence. So international human rights law traditionally, before CEDAW came along, had focused on the public or male spaces, but violations against women often happen in the private sphere, particularly when we're talking about domestic violence and we're talking about violence within families. CEDAW is groundbreaking in that it covers both the private and the public sphere. So when CEDAW looks at the right to family life, it's looking at the individuals within those families and the rights that they hold, rather than the right of the family as a whole on its own. It also looks at the individuals. So for me, CEDAW was and remains absolutely groundbreaking in really trying to, what I would, well, somebody much smarter than me coined the term thickening equality. So not just a very shallow, very formal style of equality, but a much thicker, more substantial form. And as to why now, why at this particular juncture that we need CEDAW in domestic legislation, I would say that we are facing a quite unique time in terms of threats to rights and indeed the actual rollback of rights that we enjoy in the UK right now. So the first thing I would point to is the Human Rights Act. The Human Rights Act is limited, but in important ways, it has upheld the right to women. One of the cases I always look at is the case of Siobhan McLaughlin, who was unmarried and therefore ineligible to receive a widow's pension after her partner died. She had been cohabiting with her partner for 20 years and was left as the sole carer of 4 children. She was able to use the Human Rights Act to ensure that even though she wasn't married, she could still be counted as a spouse, because of course she was a spouse in terms of how her life was lived. The other big case for me in terms of women, and as Jocelyn mentioned, I am from Northern Ireland, is the case that the Northern Ireland Human Rights Commission took to the Supreme Court, which used rights within the Human Rights Act. Now, while there was a technical difficulty in that the Northern Ireland Human Rights Commission was found not to have standing, it was found that there was a breach of rights. That, and also a 2018 inquiry by the Committee on the Elimination of Discrimination Against Women, are 2 clear factors that led to the change in law regarding abortion in Northern Ireland. And indeed, the law in Northern Ireland directly references CEDAW recommendations. So that's been really important for us. There's still a way to go to realise the law in practice, but it's been a massive breakthrough for us, and one I didn't think that I would see anytime soon. So that has been fantastic. Aside from the threat to the Human Rights Act, there's also to put it bluntly, we have left the European Union, and that has the way in which we decided as a country to leave the European Union has repercussions for women's rights. I talk about it in 3 main categories. The first is the loss of the European Court of Justice. So the European Court of Justice, apart from in some limited ways in Northern Ireland to do with issues impacted by the Northern Ireland Protocol, no longer has jurisdiction within Northern Ireland. Michael Ford QC before the Brexit referendum put it quite well, I believe, when he said that the European Court of Justice has repeatedly acted to correct decisions of domestic courts. And he was particularly talking about in relation to the rights of female workers. So the European Court of Justice, and particularly in terms of pregnancy discrimination, has pushed the UK forward over the years in how we think about discrimination against women. European Union law itself also has really moved forward the rights of women in the workplace, mainly in terms of equal pay and sex discrimination. There's a lot to be said about the gaps that European law had, particularly in terms of women who were not seen to be economically active. So carers, we know most carers are women. It was very weak in terms of that, but in terms of female workers, there was a lot of strength there. And as that law is no longer protected, the UK government does have the choice to start stripping it away if it wants. The final area then is the European Charter of Fundamental Rights. The European Charter, which of course only did apply to EU law, was a red line for the UK government, so that's gone now from UK law. We're no longer protected under the Charter. And it again had one of these really progressive equality provisions, which didn't prohibit those ideas of positive action as ways to facilitate de facto equality. The other thing is we've already fallen behind the European Union. There was a work-life balance directive that went through in 2019 that will not apply to the UK. And in addition, there's a new proposal from the European Commission on pay transparency, which obviously has implications for helping to equalise pay, and that we will not enjoy that. So I would say at this juncture, with the threat to our rights because of the Human Rights Act and with the implications of Brexit, now more than ever, we need to see that domestic implementation and application of CEDAW as a way to ameliorate those losses, and also to ensure that we continue as a society to push forward on the rights of women. And as I said before, CEDAW to me is a particularly useful convention because it tries to realize the full spectrum of rights that actually reflect the lives that women lead in all their complexity. and Debbie in particular, and Moira as well, and Sarah had all spoken in different ways about intersectionality, whether it's Indigenous women, refugees, Black women, or disabled women, or a combination of all those. CEDAW does try to realise that complexity, and the Equality Act is not fit for realising the actual complexity of women's lived lives. We have been watching with great interest what's happening in Scotland as they look to implement some parts of CEDAW through the Human Rights Bill. We note the recent UK Supreme Court judgment in relation to the Scottish implementation of the Convention on the Rights of the Child, and we think that's mainly technical details Scotland are going to push forward. However, it will have to be within their devolved competencies. Obviously, if the UK government at Westminster decided to bring CEDAW rights within domestic application, that would apply to all laws in the UK, as Parliament is supreme. So I think I'll leave it there.
Thanks so much, Helen Flynn, greatly appreciated. We've now got time for questions, but before we move to questions, I'd just like to make a comment about this issue of intersectionality, because in some ways the word is not as descriptive as it could be. And I think that we do have to think about language very clearly, because in some respects, there are so many people in the judiciary, in the parliament, etc., who are really at the basic stage of not really understanding these issues, although viscerally, I'm sure they do. But I'd just like to give an explanation or a description of a case in which I was involved back in the 1990s, where this issue of intersectionality became so clear. It's a reported case, so I can refer to it by name. Katja Fares came to, as an Australian case, she came to Australia from Europe. She was originally from Hungary and came to Australia via what was at the time East Germany. And East Germany was very much into mechanisation of the clothing industry and seeing the clothing industry as a real industry contributing to the general revenue and so on. She worked in the clothing industry in Victoria, and then she went to teach at the Technical and Further Education College. And there she experienced what she understood to be discrimination against her as a woman, and because she was what they call in Australia, new immigrants, or non-English speaking background. Anyway, she made a complaint to the powers that be, and the complaint was accepted. And then there were efforts made to resolve the problem within the division within which she was working, but it wasn't resolved. So in the end, it came before the Equal Opportunity Commission or the Equal Opportunity Board. And all the way through the case, I was actually thinking, is this about Katja Fares as a woman, or is it about Katja Fares as somebody who fits into the non-English speaking background category in Australia? That is, somebody who was not seen as of Anglo background. We won the case and actually won $55,000, which was a record for that time, and it's still not inconsequential in terms of awards in equal opportunity. It must have been 1994, I think. But therefore, it was never really ever articulated, is this about her as a woman, or is this about her as a non-English speaking background person? But what became really clear to me through that case is that a woman like Katja is not a woman with a bit of race or ethnicity sort of stuck on. And nor is she a person of race or ethnicity minority with a bit of woman stuck on. She's a whole human being. And equal opportunity and anti-discrimination law don't recognise that. If we look at the the Equality Act in this country of 2010, it divides up issues of race and sex and gender and disability. It doesn't see these attributes, identities, or protected characteristics as associated with an individual as a whole human being. And I think, therefore, that we need to begin to think about language that can properly describe the real experience of individuals who do have multiple so-called protected characteristics. But having made my contribution in those terms, I'd like now to turn to Nazir Afzal. A question has come in, but it has arisen from what you said, Nazir, and what we all know, which is the real problem in this country and globally of violence against women. So in your previous role, you advised the Metropolitan Police about how changing policing priorities could help prevent violence against women. Could you explain how this would work? That is, why you would support the incorporation of a Women's Bill of Rights under CEDAW, updated, in this country? What difference would it make? And how could it actually address this issue, specifically of violence against women? Thanks, Nazir.
Thank you, Jocelyn. There's two elements to that. One is in terms of what a national priority could be. And I've always spoken up in favour of making violence against women a national policing priority. The reason for that is that county forces, the general melee of policing, because of the way it's broken down, they make choices and they decide what their priorities are, unless there's a national steer. And so government have made a steer, for example, that terrorism, serious organised crime and child sexual abuse should be national policing priorities. And therefore, police forces have no choice about resourcing them. But strangely, violence against women is not one of those. And that's something that should follow as night follows day. The broader issue that you raise around the advice I've given to police forces in the past stemmed from a conversation I was having where I went to a senior police leaders conference, and they had a PowerPoint of their priorities. And number one was terrorism, number two was serious organized crime, number three was whatever it was. And violence against women was further down the list. And I said to them, all the research shows us, for example, that the first victim of an extremist stroke terrorist is the woman in his own home. Joan Smith wrote about it in her book only last year or 2 years ago, and obviously I contributed to that book. And her research, everybody's research has shown that actually you can disrupt people who are on their way to committing the most terrible terrorist acts if you work on them in terms of what they're doing to women who are close around them. We did some research internationally about 20 years ago where we looked at women suicide bombers in the Middle East. And all 7 that we identified had supposedly dishonored their families before they decided to kill themselves. So they were being controlled. They were being told what was right, what was wrong by men around them. So, violence against women is a way of being able to tackle not just violence against women. Professor Hilliard, Helen's there from Northern Ireland. Professor Hilliard from Queen's University did some research in the mid-80s during the height of the troubles there, that again said the same thing, that women were undoubtedly going to be the first victim of those who were involved in terrorism. And we know from just the work that around when any civil war or any war that happens, guess who are the first victims? It's always the women. So the reality is that when people say to you, oh, it's number 2, number 3 priority, what I say to policing and authorities generally is that if you make it your number 1 priority, you're also dealing with serious organized crime. I'll give you another example, Jocelyn, because I'm about to have to go in a few minutes. And this is a case we dealt with in East London, where 10 men were engaged in conversations that were being recorded by the security services in relation to very, very serious crime. And the police, you don't wait for them to blow something up before you intervene. But in this particular scenario, these men had already talked about raping and having committed rapes, etc., etc. And so we decided to disrupt them. We decided to go in there, arrest them, deal with them for the sexual assaults that they'd carried out, that they admittedly carried out. And we were able to somehow disrupt this cell before they went off and started blowing trains up. And so it's not a case of making it up as we go along. It is a case of the fact the evidence shows you tackle violence against women and girls, you deal with most of life's ills, and certainly most criminal ills. And so that's the easiest thing. And of course, by making it a national policing priority, that works. But by making CEDAW part of our legislation, the recognition then is that government also sees it as a key priority for all institutions. So as I said, it's a no-brainer, but clearly some people have no brains.
Good. Thank you, Nazir. Does anyone else on the panel want to contribute to this issue about violence against women and the difference that a CEDAW implemented into domestic law might make? I see that you've, Moira, yes.
I'd like to just use the example I said in my opening comments, a bit scattered as they were, that I found that working in a legal jurisdiction where sexual harassment and sex discrimination against women lawyers is as common as gossip would have it, and only recently got called out in Australia. What has made an enormous difference has been the Charter of Human Rights and Responsibilities, number one. And the second was, a most important difference, was the fact that women lawyers actually made a sexual harassment complaint to the head of the High Court of Australia about a former High Court Judge, Justice Dyson Hayden. And the head of that court had the enormous good sense, and was a female as well, which was pretty important, by accepting the complaint, investigating it, and saying how horrified everybody was that this had been going on for so long and nothing had happened. The fact is that when you have a statement of a right and the people who are in the leadership position take it up when they should, then you actually get an acknowledgement that this is not invisible. It does happen. The people who have these issues actually are telling the truth, and that true leadership means that the leaders take positive action. Now, Dyson Hayden has left the High Court and has declined to participate in anything, but there it is, it's now in a record. So my summary is, I'm much more likely to get some assistance from leaders in employment, leaders in the law, and leaders in the informal area, which benefits women and children particularly well. The problem has always been the resourcing for these cases to be addressed in the most efficient way. And since legal aid has proven to be susceptible to being chopped and made unavailable, it has fallen very much on volunteers such as myself and many other people to take them up as lawyers. But it wouldn't happen without a Charter of Rights and Responsibilities, which gives people, women in particular, and their voices, direct or indirect, the right to raise it publicly. And that has changed, I believe, quite considerably the environment of the law in my particular part of the world. That is not to say that is what's happening at the federal level. So, and the federal level is the level that actually signs international agreements, which is why your move to have CEDAW respected by the government of the United Kingdom is a tremendously important first role. And you don't actually change things until you name them, measure them, weigh them, and say, by the way, we will make this a serious accountability mechanism. We will raise this as a public responsibility. I'll finish now.
Jelson, you're on mute.
Thanks so much. Yeah, thank you. I just want to say quickly before coming to Helen on this subject that I've just been looking at the Crown Prosecution Service figures, and you know what crimes they drop and don't proceed with? Flashing, criminal assault at home and other forms of domestic violence, and rape. Those are the three issues that tend to be dropped, and it really indicates that there is a real problem in addressing crimes against women, because they're principally crimes against women. But over to Helen. Helen.
Yeah, I was just going to add into that, and I think it builds on what Moira was saying there. The way I think about this is the domestic incorporation of these types of human rights have three main impacts for me. The first one is better decisions. So having these rights mainstreamed throughout our domestic legislation would mean that they're part of the decision-making process for public authorities, including bodies such as the police service. So these rights would need to be considered whenever decisions are being made, whether that's about how budgets are spent or operational measures. The next is that it would hopefully lead to better laws. And that's the idea that if these rights were in domestic legislation, then lawmakers would actively have to consider how the laws they are making and the actions they are taking are either fulfilling or not fulfilling these rights. That's the idea that we talk about as pre-legislative scrutiny. And a robust process for that, I believe, could have real change. The final one I talk about better accountability, and that's what you folks are talking about. For me, that's a matter of last resort. The idea of being able to take legal action if your rights are not met. It's an absolutely necessary component of having rights. I believe that if rights are to be realized, then you must be able to take legal action if your rights are not fulfilled. But I would hope that with the ideas of better decisions and better laws, that a lot of people wouldn't have to go to court, because I do honestly believe that the idea of having to go to court to realize your rights is so much to put on an individual and to ask them to do, that I would much prefer to see it happen, these rights be realized in other ways.
Thanks so much, Helen. Yeah, good. Now I'd like to go to Dr. Sargent. Sarah, much of your work has been devoted to promoting and protecting children's rights across the world. How would you say that inculcating CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, into United Kingdom domestic law would advance girls' rights? Sarah, Dr. Sargent.
Thank you. I think that Helen and Moira have spoken with a great deal of insight and information about why having CEDAW in domestic law is important. So it's really hard for me to say anything that they haven't said, but I'll pick up the point that Helen has made about rights and how we don't just want to be about about enforcement of rights that have been violated, but it's also about prevention. And with that in mind, then I'll say a key part of prevention is education about rights, and having CEDAW in domestic law then provides a definitive statement and a unifying framework about specific rights, and this includes not only women but girls. So it's about education about rights, and not just educating women and girls or the police force or judges, but educating society about these rights. And you say that these rights matter if you put them into domestic law. If they're not in domestic law, if they're out there somewhere in some international framework, that's not making the same kind of statement as impact. So educating about the importance of these rights, having, as both Helen and Moira have spoken about, language, the language that addresses, and Jocelyn, as you said, that we're not just bits and pieces. You said, quote, we're whole human beings. Bringing all of that then into the domestic arena in domestic laws, I think it's very important symbolically. Words matter. And so to answer the question, I think all of those are achieved if CEDAW is put into domestic law. And this is very, very important for, girls' rights and women's rights.
Thank you so much, Sarah. Now, I know, Nazir, that you have to leave very shortly. Are there some brief comments that you'd like to make before you go? And then we'll come back to this issue of children's rights. Nazir.
Thank you very much indeed. Sincere apologies, everybody. Obviously, I've been working in tackling child sexual abuse too, and the most recent figures we had last year were 3.1 million British adults say they were sexually abused as children. So that's 1 in 20 adults, and that gives you a flavour of what we are dealing with and what we haven't been dealing with. I take Helen's point, and this is a very valid point, that actually enforcement should be the last resort. What CEDAW, if it's implemented into domestic law, enables us to do is to ensure that every authority, everybody considers it before they do something. And of course, that clearly is the answer. Well, prevention is always better than cure. And so absolutely, I've been inspired and motivated by what people have said for the last hour and a half. We're going to redouble my efforts to work with authorities here in the UK to ensure that this happens. My work, particularly in Wales, enables me to have access to the First Minister there and others. So I will pursue that with vigour. But where we are right now with the UK government is that they always seem to find an excuse not to deal with something. I'm hopeful that the narrative is changing. The dialogue is becoming less strained, and they realise that actually young people like Sarah Everard would not have been murdered if CEDAW had been in place, if the police investigated themselves for misogyny, weeded out, vetted people, and dealt with the issue before it happened, rather than deal with the consequences, as we sadly have to continue to do so. So I wish you all well. Thank you very much indeed.
Thank you so much, Nazir. Very much appreciated. And we'll let you go now, but saying thank you and thanks for all the work that you've done and that you're doing in this great struggle, the campaign for a Women's Bill of Rights based in updated CEDAW for the United Kingdom. Thanks so much, Nazir. Thank you. Bye-bye. Bye. And now I see, Sarah, is there anyone who'd like to comment on this issue of children's rights, girls' rights, and CEDAW that Sarah commented on? Or will I move to another question? I'll move to another question. Let me go back and see what's saying. This is one to Debbie. Would you be able to come on, Debbie, so that we can actually see you? And as the BAME officer for Ealing North CLP, you deal with instances of discrimination on a daily basis. How do you believe that having a Women's Bill of Rights would move us forward in terms of these issues that are so close to your heart and mind, Debbie? Ooh, she may have gone. Debbie, calling you. No. Well, does anybody else want to contribute to this question about Black and minoritized women and how Black and minoritized women would be advantaged? Let me give you an example. When Sarah Everard was murdered, and we can acknowledge she was murdered now because there's been a plea of guilty and a sentence in relation to that particular crime. But when that crime came up, there was a lot of protests. Why is so much attention being paid to this white woman when there are so many Black and minoritized women who are murdered and the same attention is not paid? Now, similarly with the Gabby Petito issue in the United States, there's been protests from Native American women saying they're disappearing, they're being murdered, and this same protest doesn't come about. Now, I understand that issue absolutely. the same time, I would say that when attention is paid, then it does give the opportunity for us all to say, what about the Black and minorised women? What about the Native American women? But how is it that we can address this issue that if there was a Women's Bill of Rights, it would not just be focused on those who are not Black and minoritized women? And how would Black and minoritized women have a real opportunity for rights through this mechanism? Who'd like to respond? Come on, Sarah, because your field. Oh no, Moira. Moira. Yeah.
Sarah,
Thank you.
Look, my passion, as you know, is children's rights. It always has been, and I do whatever I can here. But the important thing is that we need to talk about this all the time, because we have had in Australia a large number of women who've died in police hands. In custody, and they have never ever been even charged for what they have done, and their deaths have gone unremarked until their families got out there and said, "Hoy, over here, this is now a plague." And so we need to be talking about it at all times. And the second thing is, if we succeed in getting CEDAW acknowledged as part of the human rights protection for women in the United Kingdom, and I say we because all women have a natural interest in making sure this does happen, then there is no reason why we shouldn't also have the appropriate protections in place requiring publicly accountable bodies to prevent violence against women who have disabilities, who are Indigenous, who are of minority religious or other cultural things, who look Black and are therefore regarded as somehow different and less important. Those are the things which I think need to happen. Just remember, in Australia and in New Zealand, it was our countries signing up to the Convention on the Elimination of All Forms of Discrimination Against Women way back in time that started the impetus for the establishment of human rights commissions and a great deal of other support to women so that they could address the things that were holding them back and destroying their lives and their own family lives. So I think Sarah can say much more than that, but you start with women, and guess what? Everyone's got a mum or a daughter or a sister or something like that. And people start to understand that the rights of women are the central rights that we have to start dealing with effectively. I entirely agree with everybody, including Nazir and you, Jocelyn, saying that we must prevent these things from happening. You can only prevent it if the people who are turning a blind eye to it are accountable for turning a blind eye to it. If the organisations which are saying we're very much working for women, and one of them I'm working for at the moment, actually are accountable for, in fact, how are we dealing with women in the workplace? The one I'm working with at the moment is all full of women's rights talk, but it's not until the Commission for Gender Equality actually asked them to come up with a Gender Equality Action Plan that they analysed it and found, guess what, there was a pay gap in their own organisation and there was gendered segregation. So the men who were in the organisation were getting paid significantly more than the women. And all of this stuff happened right under their own noses. We must be aware of it. You have to raise it all the time. And
thanks. Thank you, Moira. Yeah. I think that this is obviously a real problem, a real issue that touches us all. Could we, may I just go to another question to Helen Flynn? Helen, this is about COP26. Let's just move for a moment to the whole issue of climate change and the impact on women and girls. On the 11th of October, ahead of COP26, Just joined 160 civil society and Indigenous groups and academics across 53 nations in signing an open letter to put human rights at the centre of environmental policy. You state that, just a sec, sorry, I've lost the question. you state that the climate emergency is a human rights issue and must be treated as a human rights issue. What about the disproportionate impact on women and girls, and would having CEDAW in law as a Women's Bill of Rights or a gendered approach to climate policy help? Helen, over to you.
Short answer, yes. And I think this also links to what we've been discussing in terms of how people live their lives. You know, for me, the climate emergency very much can't be an add-on. It needs to be integrated in how we think about human rights. And within the UK, I mean, we know that the two main threats are the warming climate, so you know, periods of extreme heat and also flooding are going to be the two. We also know that those who are already facing inequalities in our society are likely to be most impacted by those two emergencies. So we recently called on the Cabinet Office, when it was looking at its resilience strategy, to think about the incorporation of international human rights standards. In doing so, because a more equal society, we believe, is a more resilient society coming up to face the climate emergency. We also recently, actually I just published a blog on it on our website today, submitted evidence with the Women's Budget Committee on the climate emergency, well, about a more equal transition. And we talked about the climate emergency in terms of how the care economy hasn't been considered properly as part of a green economy and as part of a way to create carbon neutral jobs. And from my work, as mentioned, that was something that came up in the Feminist Recovery Plan for Northern Ireland, the fact that when we're thinking about a green economy, we're not thinking about the care economy enough, and how the care economy can be part of that Green Deal and a carbon neutral way forward. So there's information on our website just posted about that today, or else there's a lot written on it by experts in the Feminist Recovery Plan, not me, experts on the care economy.
Thank you, Helen. Yeah. Sarah or Moira or Debbie, do you have a contribution on this issue of climate change and the place of women and girls and a Bill of Rights for women? Or do you consider that we should? Oh, yes, Sarah, please.
So I think the idea of rights all being integrated is a very important one, and not just as an academic statement, but as Helen and others are pointing out, it's real. It's how we lead our lives. We don't lead our lives in silos. And I think this idea of considering the effects of climate change are really important across all sets of rights, and certainly in CEDAW. Again, you've got to think about who's going to be impacted. How are they going to be impacted? And so climate change issues mean lack of access to water, lack of access to food, excuse me, lack of access to, the very basic needs for human life. And excuse me, if we look at information that says women and girls are going to be the first, speaking quite broadly, to lose access to food and water in times of shortages, then it becomes even more critical that the effects of climate change on girls and women is considered. And in speaking about this, I don't want to suggest girls and women are homogenous. People have different lives all around the world. But it's kind of impossible to avoid making a general statement around such a big issue. Absolutely, the way in which all of the different implications of climate change impact people in their daily lives. It's not about just sort of the bigger issues of a gas boiler or a green, friendly to the environment boiler. It's about even more fundamental parts of survival in many places, about access to water and access to food, that's only going to become more critical as climate change goes on.
Thanks so much, Sarah. she was speaking, I was actually thinking about Bill and Melinda Gates. Now, some years ago, Bill and Melinda Gates gave a grant to scientists, I think it must have been in California or in the US. And the grant was given for these scientists at the top-notch level to work at how we could have loos, that is lavatories or toilets, that were environmentally friendly. Now, while they were giving out this money to top-notch scientists in the United States, women in the Pacific had for years worked out how to have environmentally friendly loos, lavatories, toilets. I had been at a conference in Fiji way back in about 2002, and the women were talking about this as a part of the conference, which was about the environment, and they'd been doing that for years and no doubt for centuries. And here we have a foundation giving thousands of dollars to scientists. It's something that women had worked out all by themselves, and it was unnecessary to give the money to the scientists. But of course, this happens because there's it's an issue about elitism and about not having the capacity to see that people who do not have formal qualifications in the way we think of formal qualifications, if they haven't got any intellect, intelligence, capacity, or inventiveness. And often they have far greater inventiveness than those who have gone through the university process. Now, we've got chance for some more discussion. And one of the issues I actually wanted to come to is to Sarah. It is this issue about getting equality rights into a constitution or at federal level, because we know that in the 1970s, the Equal Rights Amendment, well, it was originally put into Congress in 1923, and then it came out in the 1970s, went round the states and was ratified. I think it's 38 states you need, and there were 35 states ratified it. Now it's gone, but it's got the 3 extra. Virginia was the last one. What do you think, number one, what are the chances of the Equal Rights Amendment? And number 2, how in the United Kingdom do we address the problems that arose in the United States in terms of trying to get the Equal Rights Amendment into national law? Sarah.
That's a good question. When you were talking about that, you made me think of my mother, who in the 70s became a community activist and was very much a campaigner for the Equal Rights Amendment. And as a child, I have early memories of going to campaigns and rallies with her around the Equal Rights Amendment, and of her very, very grassroots. And she, she was someone who had been at home raising children, but felt this was so important. She just sort of went out there truly in a grassroots way to become involved. And so that stands out to me as a memory. Yeah, so very disappointing from my perspective then that the Equal Rights Amendment got so close. Is it important? Of course it's important. As I said before, and as all of the speakers have been saying, words matter, but we need more than laws, because we can point to any number of laws that are ineffective, that don't do their job, or that people don't know how to access, or that trying to access what's on offer is too expensive, too remote, or in the instances of domestic violence, could pose a risk to the woman or girl who needs to have the access to the rights. So the Equal Rights Amendment and a statement about equal rights, such as you would get with a Bill of Women's Rights on CEDAW, I think is important. One, again, because of the symbolic value of words. words matter. And once those words are enshrined in something that's given formal recognition, then they become a platform for statements about rights. And from that, then efforts can build. So I think it's really important to have laws and legal statements in place, but to me, again, that's the beginning of the work, not the end of the work. It's once that is there, you've got the essential building block to then carry forward. So it's not job done, it's job started. But I fear sometimes that in the work of campaigning, sometimes these words just become rhetoric, and the steps that all of us have been talking about then, about access to rights, prevention, education, those also need to be part, I believe, of any meaningful implementation of equal rights for women in any form.
Sorry. Thanks, Sarah. Thank you. And I just come to Helen because we've had this decision about the Scots effort to have the Convention on the Rights of the Child incorporated into Scots law, and you spoke about that. Perhaps if you just reiterate briefly on what impact you think that decision will have, and whether it could be a stumbling block for what we want to do in terms of getting a Bill of Rights through the United Kingdom Parliament. In some ways, it supports that rather than.
Yep, sorry, your audio was a bit, so will I go ahead? Yeah. Okay, so the recent Supreme Court decision on the Convention on the Rights of the Child, I think firstly, what worth noting is that it wasn't a huge surprise. Perhaps the Scottish Government was trying to push the envelope a little bit on what the powers of devolution are. I don't think that they were wrong to do that. How do you know where your limit is until you test it? But now we have clarification. So we know that this is beyond the powers. It's time for the Scottish Parliament to get on with pushing through the UN Incorporation Bill. There's nothing insurmountable in what the Supreme Court has said. There is plenty of scope for the Scottish Government to push through the NCRC and then to proceed with its Human Rights Bill, which would seek to incorporate, amongst other things, CEDAW in Scots law. And what I find actually really fascinating about the UNCRC Incorporation Scotland Bill is that not only the bill means, amongst other things, that public authorities can't act in a way that's incompatible with the UNCRC. Courts will be able to strike down legislation that's incompatible with the UNCRC within the devolved legislature. This won't apply to reserve matters, I would imagine now. But also the Scottish Government must publish a children's rights scheme to show how it's meeting the NCRC requirements, and it has to review that scheme once a year. And again, I'm coming to this idea that it's not just about rights being enforceable at courts, but it's as much, the importance of incorporation is as much about the government and public authorities checking what they're doing and whether they're meeting rights and where they can do better. So that's really powerful. And to me, this bodes really well for incorporation of CEDAW, because if we are having these rights for people in Scotland, and if Wales are looking at pushing forward with other aspects of UN human rights systems, then why are we not pushing for them in England? And of course, in Northern Ireland, there's a very separate but linked discussion about a Bill of Rights that was part of the peace agreement there. So I think it's very positive news, and my main takeaway from it is time for the Scottish Parliament to get on with the UNCRC Incorporation Bill. Get it done.
Yes, exactly, Helen. Thank you. I know we're coming up to 4 o'clock, p.m. in England and to 2 a.m. in Melbourne, Australia. So perhaps we should wind up. And I'd like to come back to Sarah, Helen, Debbie and Moira for some final thoughts to wind up. If you'd like to make some short remarks before we come to the end. So back to Sarah.
Thank you. It's hard to add to what all of the speakers have said this afternoon. And I think all of the dimensions of why this is so important just simply need to be underscored. And I would just like to say thank you for being able to be part of this. It's, I think as Nazir noted, it's been really inspirational and energizing. And I think we need more of this. We need more of bringing people together, more of speaking out about these things and raising awareness of the efforts to get this Bill of Rights.
Thank you, Sarah. And over to you, Helen. And then I'll come to Debbie.
I just want to say something I probably haven't mentioned that much. We're still in the midst of a pandemic, unlike anything we've experienced in our lifetime. And I think we're also presented, though, with a constitutional moment in it. I think as a society, we have laid bare, I don't think any new inequalities were created by the pandemic. I think it just laid bare and exacerbated existing ones. And I think as a society, we're a lot more conscious about what people are going through and what people are suffering. And I think that if we're talking about building back better and we're talking about how to have a more equal society, then now's the time. Now's the time to be pushing for our rights to be realised, including through bringing CEDAW into domestic legislation. So my takeaway from this is that I think we have a moment in which we can really make a push, and let's call for a better society.
Thank you, Helen. Now over to you, Debbie. Thanks, Debbie.
Thank you so much. And I really want to thank you for inviting me to this, Jocelyn. It was more than what I expected. I'm also glad that we have a male on board, because with his network, he'll be able to give us the push that we need. I've just picked up a little one here. So yeah, I support this. I've already shared it in my network. If there is a template that we can petition MPs and whatever, please share that template to me and I will share it in my networks. What else can I add? As you said in the introduction, the issue of objectifying women's body, and I'll go back to where I suggested that we need to acknowledge and define what the discriminatory behaviours are. Because recently Ireland had their first Black female win a pageant, and some women in the Black community would think that that's progression, that Black beauty is being acknowledged. But I'll play devil's advocate and ask, is it? Do we have to objectify our bodies and to be recognized as beautiful is versus community efforts and, you know, what you're doing locally in your community? So there's so much education to be done. And especially when I said about defining what is the discriminatory behaviors, what is the violence that women experience. I experienced financial abuse, as I said before. You know, as soon as the relationship dissolved, you know, I had to go out and find an additional income / incomes because assets were being hidden. So, you know, women, there's a lot of work to be done, and we have to put women and the family and the little individuals of the family first. And we have to educate young boys and men and the male-led world that we're in right now. So thank you so much for inviting me, and I look forward to supporting.
Thanks so much, Debbie. And now over to you, Moira, for some summing up. Thank you, Moira.
Okay, my sermon for today is, after nearly 2 years of a pandemic, one thing we know for sure is that women have suffered the most when it comes to the effects of having to work from home, losing our jobs, losing our incomes, and having to do all of the caring as well as half the education, or more than that, from our own homes. That's point one. The pandemic has shown us how vulnerable women can be when big decisions are made without thinking about them in particular. Number two, it is now clear to me, at least, that we cannot go back to the way we were before these chasms in our social networks became so obvious. We have to find a different way of working. I entirely agree with Helen that there is a time and a tide when we should do something. And I have found in the work that I've been doing, which has been a lot of it online and talking to people far more intensely than I have been able to do when working in my little law office in the city, I've found a willingness to talk about human rights and to talk about the need to make decisions when one is fully aware of the impact on women and children in particular, and vulnerable groups who have rights to be treated with respect, such as Indigenous and other groups that have a very precarious hold in things. And my final remark from me is, I know I speak with a good old Australian accent now. I've practiced having that, and I came to Australia somewhat later in life. But there is a New Zealand phrase that is becoming used a bit more, not just in my home country, New Zealand, Aotearoa, but also in Australia. And I want to finish it with it by saying it 3 times. It's kia kaha, kia kaha, kia kaha, which is Maori for stay strong. This is what we need to do. Kia kaha.
Thank you. Thank you, Moira. So it's almost time to finish and to say thank you so much, first of all, to Nazir Afzal, who's already left us, to Dr. Sarah Sargent, to Helen Flynn, and to Moira Rayner, and to Debbie Allen. I'd just like to make 3 summing up points, if I may. 1, reconstruction, recovery, and renewal. We've mentioned the COVID-19 and the pandemic. And what we need to make sure is that women are the leaders in reconstruction, recovery, and renewal, and that the money that is coming out to effect reconstruction, recovery, and renewal must come equally, if not more so, to women. That's number 1. Number 2, education's been mentioned. Now, those who must be primarily educated are the judiciary, the magistracy, the police, and others working in the polity. Nobody should be allowed to stand for Parliament unless they have been educated into the meaning of CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. And similarly, in other elected roles, those who stand for election must have mandatory education in this field, police, of course, too. And then 3rd, public funding for elections. In my view, no political party should get public funding for elections unless they have made sure that all their candidates have been properly educated into CEDAW and women's rights, the Bill of Rights, and undertake to have regular education in that from that time forward. And I'd like to end, if I may, with some words from Simone de Beauvoir, because the problem here is that as long as women are not recognised as human and as equal persons, as equal humans, women's rights as human rights and human rights as women's rights, women will continue to be killed, women will continue to be sexually harassed, women will continue not to have opportunities in the paid work sphere, and the pay gap will not change. As Simone de Beauvoir said, women's drama lies in this conflict between the fundamental claim of every subject, which always posits itself as essential, and the demands of a situation that constitutes women as inessential. One must therefore ask, how in the feminine condition can a human being accomplish herself? What paths are open to her? Which ones lead to dead ends? How can she find independence within dependence? What circumstances limit women's freedoms, and how can she overcome them? I added to that, how is it that men must work solidly to ensure that it's not simply women overcoming these problems, the obstacles that confront women, but it's men who physically knock down those obstacles, the obstacles that they have created through creating or adhering to a patriarchal system that does not acknowledge and recognise women as equal human beings. So I say thank you again to Debbie Allen, to Helen Flynn, to Moira Rayner, and to Nazir, and to Sarah Sargent, and say we'll end now more seminars and events such as this in order to ensure that a Women's Bill of Rights becomes the law in the United Kingdom. Thank you and goodbye, and Moira, good night to you. Bye. Bye. Thank you. Thank you.